All right. Thank you. State anything in rebuttal?
Yes, Your Honor. What the Floyd case stands for is that charges are charges. You can resist in different ways if found guilty to the charges would have been merged for sentencing. As far as the way that the crime trespass is charged, that is the correct charge. It's not required to be a residence. It's a building other than a residence that does apply to and then applies to the land, so those are in fact charged properly. State-supported property is not appropriate in this respect. This is a building that a federal building, but I'm not going to get into a whole jurisdiction thing, but the correct charge in this is criminal trespass to real property, that being a building other than a residence. For intent, we've got the intent that they claim to be perfectly innocent here today, except we did delve into a little bit of some suspect intent, such as did it so I could post it on the internet versus the intent that's evident in the video. It's very clear what the intent of the defendant was. He wanted to get the parties in the video to call the police. Yes, defendant was out in the car, but you heard that he had come in once already. No mask, but wasn't seen, so then guess who comes in next? Beverly and Trinity, all the way up to the cash register. They were waiting for the opportunity. Beverly was fed up with being told she needed to wear a mask. They were waiting for someone to tell her that she needed to, and the second that happened, Trinity was at the door waving Dad inside. Your Honor, you're going to get educated? That is 100% threatening. It was threatening in the tone. It was threatening in his advancement, and it's something that every single person testified was concerning to them that heard that statement. As we said, you never know what's going to happen, especially when someone appears to be going off on some irrational tangent. Your Honor, videoing is one thing. Counsel said they were simply having a conversation. Simply having a conversation doesn't end with more than one person saying I'm calling the police. Videoing with the intent to incite is completely different. There is no fundamental right to threaten. There is no fundamental right to harass. There is no fundamental right to alarm and disturb at all, ever, in front of video or not. Even if your purpose is to make people internet stars. Your Honor, people do have an expectation of privacy sometimes in a public building. For example, when you're taking your debit card out and typing in your PIN. There is a reason that the post office doesn't allow people to video by the cash registers. Your Honor, defendant knew he was being arrested. Defendant himself testified that Officer Brox said he was going to jail. Officer Brox, when she testified, didn't say that she didn't say you're being placed under arrest. She said she simply didn't remember exactly what words she used. Defendant says he was pushed to the ground and landed in this spread eagle position we saw him on the video. Pushed? No. Pushed into that position means your face bounces off the ground. He wasn't injured. He was brought to the ground and then he was stiffening up. Still, to make sure that he was accomplishing what he needed to accomplish. He needed his daughter to catch that video. I'm not resisting. Where does that word even come from? He was resisting. And he was trespassing, and prior to that he was being disorderly. Your Honor, I ask that you find him guilty on all counts.
Judge, can I briefly respond?
Sure.
As to the criminal trespass to real property statute, it clearly states that when one without lawful authority enters and remains within or on a building enters the land of another after receiving notice from the owner or occupant to depart. Owner-occupant refers to an individual or a renter, which is why trespass to real property and not government property, which is why we don't believe this statute applies to the government federal building of the post office, and there is a specific statute for government property. If this referred to government property, they wouldn't need a separate statute. As far as my client being brought to the ground with the arrest, the video clearly shows how fast Officer Brox went from telling him to leave to immediately going hands-on with him. She failed to say he was under arrest. Within that short amount of time and the few seconds it took to get to the ground where the second video started, it was a very short amount of time. My client said that he braced as he fell. Once he got to the ground, he then put his hands behind his back where you can see that it picked back up. In that short amount of time, it's not unreasonable that someone would have happened so fast that he wouldn't know he was being under arrest. The second he did, he testified that he immediately put his hands behind his back. The state keeps focusing on somehow intent to disrupt. The whole totality of the circumstance don't show that. They said they went there to mail something. The postal worker said that Yes, they were helping her mail something. My client's daughter only went out again when there was an argument. They didn't know there was going to be an argument that happened. They didn't go out there with the intent to film. He's not a person. Auditor. He just knows based on watching those videos that he does have a right to film in public, and everyone testified. My client, his wife, and his daughter all testified that they had no intent of going there with the intent to film or disturb. Even if one went to with the intent to film and put it online and disseminate it, he still has a right to film the public. It doesn't matter his intent. It matters on the conduct. And it's also not a subjective standard of whether he was disorderly and caused a breach of the peace and whether the people were subjectively alarmed. It's an objective standard, which was the actions unreasonable. Just because one person is alarmed by seeing someone film them, that doesn't automatically make that person's actions unreasonable. All he did was film. He never made any threatening statements. No matter how the state wants to construe saying someone is going to get educated, no reasonable person objectively would find that that's a threat. Based on all that, we believe that the state can't meet their burden on any of these counts. Thank you, Judge.
Thank you. Thank you to counsels for their presentation. I'm going to take this under advisement. There's a lot to sift through. I guess a couple matters. State, do you have, okay, you beat me to the punch. You have your exhibits and then the cases you were referencing?
Yes.
Your Honor, I have the case too, Judge.
You have the cases you referenced.
Yeah.
Thank you.
And then 5 was not admitted. It was simply,
That was to refresh recollection, right?
yeah.
Okay, thank you.
To clerk.
And then, Mom Clerk, is it okay if I leave these with you? Okay? I didn't know if you needed to inventory them. Okay, and then let me see. Today is the 26th. The 20th we're running into a holiday. I'm not sure of the party's schedule. The week of February 20th is a jury week here, so I'm kind of looking in the 3 to 4 week time frame, but
I think the 20th is a holiday. I could do the 21st?
that's the week that's a jury week here.
Oh.
Yeah, the 20th. I'm looking at maybe the 27th.
That's good for me.
That works for me, Your Honor. We have a bench trial set that afternoon. The morning is my plenary call, but I imagine we could. Attorney Babcock's Poole, obviously. We have no way of knowing now whether that's going to go. Keselowski, but which one?
Keselowski, concealing an animal.
That's actually now Attorney Johnson's.
Okay, who just left?
Yes.
And I'm not going to hold you to it. It's just for scheduling as to whether we think that's going to go or not, but
I don't know.
right. We won't know probably until it gets closer, and obviously, you won't know probably until that Tuesday, the 21st, whether or not any trials are going to go that week. Right now, what about February 24? That's a Friday.
I'll be in Will County that day.
Okay.
The only ones I have are the 27th or the 1st of March.
March 1st might work. How's that new courthouse in Will County? I heard it's nice.
It's nice. Yeah.
I heard.
It's a lot better than that other dungeon of a courthouse that they had.
How's March 1st? That's a Wednesday at 1:30. I know there is SSS set, but those rarely go.
Sure. That works for me.
And that works for you guys?
That's good for me, yeah.
Okay. Wednesday, March 1st at 1:30. That will be for decision. All right. Thank you, everyone, again.
Thank you, Judge.
Thank you.
Case concluded at 2:51 p.m. State of Illinois in the Circuit Court of the 17th Judicial Circuit, County of Boone. Certificate. I, Gina I. Rubino, an official court reporter for the Circuit Court of Boone County, 17th Judicial Circuit of Illinois, transcribe the electronic recording of the proceeding of the above entitled cause to the best of my ability, and I hereby certify the foregoing to be a true and accurate transcript of said electronic recording, which recording contained my operator's certification as required by General Order 16.01c. Gina I. Rubino, CSR Official Court Reporter License Number 084.004378. Date signed, 2/11/2023.